Good.
Good morning, sir. You Desarian Adams. This is 23 DCCR 0492 and 0493.
NTRP announcement.
On both cases, correct?
Yes, Your
What's the announcement?
Honor, they've made an offer, but we're gonna need a hearing on this. We can't come to them.
Okay, so did we already go through the motion?
We did,
Or did we start going through it and then stop? Because I didn't make any notations of pleads of true or not true. I don't think.
You didn't make any on this one either.
what we did was I was read through to all the violations except the new allegations, which were the misdemeanors. And you said, no, we gotta do them all. So we stopped. There's 2 misdemeanors there. I think one's a shooting.
Okay, I mean, and I wouldn't have said, I mean, I guess as far as an agreement goes.
We were gonna go on work, but did not.
He did plead true to counts 3, 4, 5, 6, and 8. And it was reset for an update. So it's, you know,
Something happened and we stopped because I didn't make the notations and we didn't get it updated. So let's start back from scratch. We'll go through the motion, get pleas of true or not true, and then we'll reset it for a hearing. No, ma'am, I'll take care of it. Oh, there's 2.
Yeah.
The second one, please. Okay, so Mr. Adams, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can put your hand down. And will your client waive the formal reading of the motion in each case?
Well,
So, Mr. Adams, in cause number 23, DCCR 0492, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 26th, 2023 for the 3rd degree felony offense of deadly conduct, discharging a firearm. And that was a 5-year deferred probation. Is that correct? And then in cause number 23, DCCR 0493, I also have a motion to revoke your unadjudicated probation. This also shows you were placed on probation September 26th of 2023 for deadly conduct, and that was also a 5-year deferred probation. Is that correct? Both of these cases allege that you violated your probation. Count 1 in each case alleges that you committed the offense of fleeing a police officer December 6th of 2025. Is that true or not true? Count 2 in each case alleges that you committed the offense of unlawful carrying a weapon December 6th of 2025. And is that true or not true?
not true.
Count 3 in each case alleges that you failed to avoid persons or places of disreputable or harmful character, and that on December 6th of 2025, the arresting officer stated that the vehicle operated by you and occupied by 2 passengers emitted the distinctive smell of burnt marijuana. Is that true or not true?
Not sure.
Count 4 alleges that you failed to immediately report your arrest to the probation department. Is that true or not true?
That's true.
Count 5 alleges that you failed to provide verification of performing the community service hours as ordered in each case. Is that true or not true?
Yes, not true.
Okay. Count 6 alleges that you were at a location other than your residence at approximately 11:23 p.m. December 6th of 2025. And is that true or not true?
True.
Count 7 in each case alleges that you were in possession of a firearm by having 3 pistols located on the back driver's side seat concealed under a black jacket in the vehicle that you were driving. Is that true or not true? And count 8 alleges that you're behind in your court assessed fees as of December 8th of 2025. In cause number 0493 in the amount of $540. And in cause number 0492 in the amount of $2,942. Is that true or not true? Okay. Did you enter your pleas of true in each case to counts 4, 6, and 8 freely and voluntarily? I'm sorry. And did you plead true to those counts because they're actually true? All right, then I'm going to find those counts true, find that you entered your pleas freely and voluntarily. find sufficient evidence in each case to revoke your probations and find you guilty, but I am going to reset this case for a hearing. Do you anticipate, I guess, a little bit of time on this one with witnesses?
Think so, Judge.
Like,
There's nothing offenses.
I'm sorry.
An hour.
Okay, all right. So we'll get it set for a hearing. I'll get an updated pre-sentence report and,
We'll have some.
okay, we'll do it on a different day than a docket day then. All right, you can go back with the bailiff.
Did you order this?
Big excuse me.
Yes, thank you.
Mr. Adam.
Good morning, you're Larry Fitzgerald Williams. And this is cause number 25 DCCR 0985 and 24 DCCR 1790. Mr. Williams is charged with capital murder as well as aggravated assault causing serious bodily injury. And what is the announcement, Mr. Passion?
We need to take care of some housekeeping matters because the last time we were here, you had ordered the state to provide us with written notice whether they're going to seek the death penalty. And yesterday afternoon when I left my office, I had gotten nothing from the state as to whether or not they're going to seek the death penalty. And I would like that information as soon as possible in accordance with the order that you have.
Mr. Smith?
State's not seeking that penalty, Judge.
Okay, if you'll get that in writing to Mr. Cashin, so he has it for his file. That way we can, that gives him the opportunity to know how to move forward. I'd like to get this case, if it's going to be a trial, tried before the end of the year.
Yes.
And so I want
I
to,
agree.
And there are some other issues, Your Honor. Back when we first came to court, I had filed a motion to quash the indictment because the indictment, from what I understood, was incorrect because it was under a wrong provision and it was for retaliation against the judge. And they have not corrected that in that indictment.
just let me pull that.
Yes, ma'am.
So I think we discussed this, and it's only the heading, which is not substantive. Obviously, the substantive part of the indictment is what the actual charge is, which is the retaliation
Yes.
against Mr. Lewis. It's the indictment itself is not going to be quashed because of what's ultimately a typographical area in the top.
Okay.
I do think it's clean, or for the record, if you want to make an oral amendment, I think that's something we can do today.
Okay. Right from the state.
I think it needs to be correct as well. And it's not 18. I can't remember which one it is, but I'm gonna look. I know we had this conversation.
Yes, ma'am.
Do you remember which one it is by
In the
chance?
very beginning, well, I left that file in my office.
That's all right. I can figure it out. Let's see, 19. Go to. Nineteen oh three,
Team. I mean, that is correct.
that is correct.
1900.
1903, 18 is correct.
It is.
I can live-
There was something that I do recall us having a conversation about, but
Well, it says murder for retaliation, judge justice. I mean, that's,
oh,
that
the
we can
judge
line
justice
through
needs
that.
to be interlineated, but the
Right,
section
that's-
number is actually
Okay,
correct.
that's
Yes.
what I'm,
That's the, okay.
that need to be delineated.
Any make an oral motion to
we would
do
make
that?
an oral motion to strike that from the.
Okay, and
Hold on, any objection to that?
no, Your
All
Honor.
right, give me just a second to get it done before I move on. It doesn't want to give me that option yet.
This is where things get messy behind the scenes, when the courtroom pauses, not because of law, but because the system itself glitches.
That's weird. And we need to, did you, make a note on a ticket? For some reason, the one thing that I need, which is the interlineation thing, is not letting me do it, and it has in the past. Okay, so I'm just gonna print it. Yes, ma'am. And we'll do it that way. Okay, what else?
We recently got an email from Mr. Smith about some discovery, and I bought a 1 kilobyte, or 1 terabyte drive to be copied, the information that he's referring to.
Okay,
And so I would like that. Then I have a motion to change venue right here, but I need to get Mr. Williams to sign his affidavit, and it will be filed this morning.
okay, so with regard to discovery, y'all can take care of that.
Yes, ma'am.
I don't need to get involved in that. And then, once, if something is filed, with regard to a change of venue, I'll get that set for a
Yes.
hearing within the next few weeks.
Yes.
Obviously, that's something we'll need to get taken care of so everybody can plan ahead
Yes, ma'am.
on what we're doing. So once it's filed, I'll
It'll be,
give everybody an opportunity to get ready and we'll get something set,
that'll
I
be
would
done.
say within 2 or 3 weeks.
Thank you, ma'am.
Okay, anything else?
That's it for now.
Okay, all right, if you can, if you need him, to sign that
Yes.
in front of,
Notary.
if you can step over here in front of the clerk, she'll take
Okay.
care of that.
Thank you. Thank you, Judge.
Thank y'all.
And just like that, the hearing wraps. But don't mistake this for closure. Between discovery issues, venue strategy, and procedural friction, this case is still very much in motion. The real question now, when this finally hits trial, what version of events will actually hold up in front of a jury?